at the date, today is the 27th of February. That person was brought on?
29.
Yes. So there has not been any further additions. Yes. Yes. So we are making it clear that if there is any other person, a new charge sheet will be presented so that we can handle the 21 persons.
Your Honor, we pray that prosecution is not locked out really when, especially where the prosecution has the liberty, Your Honor, to amend as and when, Your Honor, circumstances permit. Your Honor, I will leave it at that, but I pray that...
I want to clarify that I don't want to go back to what I said then. I don't want us to get that discussion back on the floor. For reasons being that these persons have had them from the 14th of August 2025, I cannot continue allowing amendments because it is unfair to this other person. Because you can amend until 2040. If I give you the liberty to. So allow us to close that part. Amendments have been many, and also a part to the end of that, to make the justice that we deserve.
So, why the prosecution is particularly concerned,
yes,
is that if the defense succeeds in putting the court in such a position, it is going to set a dangerous precedent. We pray that these persons their cases should be treated on a case like this.
And that's what I'm saying, that even if I am to allow, I'm saying that you can't say I'm on the defense side, it will allow, because court must start a litigation. So when do we ever start?
You know, we're ready to proceed with the hearing, but
with amendments, we go back to disclosure to the beginning. Because we are using the same charge sheet, we shall even bring the same witnesses back to court for cross-examination. So, in my court, I've decided that we are stopping the amendments. I have allowed several amendments. That person is putting on shades, please remove them. Let us have order. If I came with shades here, I don't know how you would welcome me. The way you want to present, the way you want me to present myself is the same way you should come. If I came in shades to attend to you, would you be okay with it? Should we try it? So let us have some little order, at least decorum for court. Then we can do other things outside. So what I'm saying is that for us to start litigation of this case, we must stop the amendments. And amendments are not even to fact, they are to addition of persons. You're not adding charges, you're adding persons, which will lead us backwards. So you can charge this person on a different charge sheet, and still the ends of justice shall be made. So it does not stop the justice from being made, just because I've stopped an addition of person. You can open a new charge sheet and have that person prosecuted. But for now, I also cannot come here every single day on disclosure and amendment. Cannot happen. So today, the 27th of this month, February, we shall stop additions and amendments. We are going to start with these people and we'll see where they are ending. And I hope we do not go back to the same. So we can proceed with the business for today. Forward it.
Your Worship, all the 21 discussions in court, defense counsel have introduced themselves. I'm not sure if
what one can do for us is for the official court to be comfortable in court because the way she has seated you. Yes, she contributes.
Let me have the court orderly get a chair for counsel. Court orderly, help us with a chair for counsel. State, what business do we have today?
Your Honor, the prosecution had, I think, one or two sittings earlier, had referred to this honorable court to regulate the media. Your Honor, the reasons were given, we submitted on the same and shared the authorities, Your Honor. The defense, however, sought court's leave to make a response, to prepare and respond to the prosecution's application. Your Honor, that is what the court had done for, and we are ready to proceed.
Yes, Your Worship, for the record, I'm going to see. However, Your Worship, before I proceed to give my response to the prosecution application, as an officer of court, it is prudent that we guide court on how we proceed. On the 23rd of January 2026, when I appeared in court, there were only 3 judges people upon which this application was made. A21 who has just been added should not be involved in this application because he was not an accused person by that. Because I don't know what he feels of, I want court's guidance, then I can proceed.
Let's see the reply from, I am not doing.
It's okay, I understand.
He's an accused person and he's here, and I've said we read with you the charges. He pleaded.
Not surprised with the worship, but I wanted him to be.
I cannot exempt him from this file at this point.
I've understood that. I wanted him to know why we are making this reply. Because he was not happy.
And it will affect him either even if the court gives a ruling, it will affect him. So it is not, I cannot isolate him at this point.
Yeah, most obliged, Your Worship, but I wanted him to understand why we are making this reply. But you can proceed.
Is he represented?
Yes, Your Worship. He's represented. Your Worship, the state made an application, and mainly he was concerned with the breach of the subsidies laws, as well as the security of the persons involved in this matter, including the witnesses, which we think to be tried for today. Your Honor, the law on subjudice is clear. And I believe my colleagues on the defense team, as well as the prosecutor himself, they understand that matters before court should not be discussed, or opinions given on their merits or demerits. Your Honor, from the start of this trial, neither of us, the lawyers and the defense, I'm not sure whether the prosecution has, but neither of us from the defense team has ever discussed the merits or even the demerits of this matter anywhere, either in this court because we have not started trial, or even in the public. The prosecution did not even adduce any form of evidence relating to the alleged subjudice And for us, we can confirm because we know the effect of sub judice discussing matters. As advocates, we cannot do that. And we are not even about to do it. In his application, Your Worship, the state submitted that the media was doing live coverage in this matter, and he alleges that that was also part of the sub-judice, breach of the sub-judice. But I want to clarify this, Your Honor. On several occasions, the prosecutor and this honorable court have been clear that this matter before court, before these accused people, is a matter of the public interest. Your Worship, we also know that it is a matter of public interest. And considering the size of our courtroom and the number of the accused people before you, the courtroom space is small, as you can identify. Most of the people are standing there. And also, considering the restrictions from the main road towards accessing this court. At some point, it even affected us, the lawyers, but it was rectified. But it still affects the court users, the relatives of the accused people, and the sureties. Your Worship, the media only does coverage in this matter because not every relative of these accused or their sureties can access court. And some of the accused people, including A8, are leaders of the second biggest political party here in Uganda. So they have a lot of following and supporters. Whereas some of his colleagues are also in prison, by covering these proceedings by our media group, which is clearly by the media group here, helps also those leaders that are still incarcerated for court proceedings. And many of these details have already been in the public domain since August. So my submission on the sub-judice is that the prosecution has not had any evidence or even pointed out any media group or personnel that has commented on this matter in a breach of the sub-judice. The second issue, Your Honor, is about the security of persons involved in this matter. Your Honor, the prosecution alleges that the parties involved in this matter, including the witnesses, are facing a security risk because of the media coverage of this proceedings. But I've always appeared in court, and the record can clearly show that the state has always admitted not having concluded investigations in this matter. and therefore they have not fully disclosed to us the defense team. So, neither the court record nor the defense counsel, or even the accused people themselves, know the witnesses that are intended to be relied on. And you remember, Your Worship, on the 23rd, I even raised an issue about the complainant in this matter. We still don't know. So there's no threat on the security where we don't know the people that are threatened. And two, there's no evidence that was adduced by the prosecution regarding any threat. And if there was a threat, a prosecution is in a better position to complain and bring the people threatening them to this honorable court, because I know that is an offense. But in the absence of any of the facts in that regard, I find that the prosecution's allegations are far-fetched and should be ignored by this court. Your Worship, the state is actually in a better position to provide the security for its witnesses that are not yet known, and for us as defense counsel. Because, Your Worship, we the defense counsel are much threatened because we are representing these people by the security itself. And Your Worship, for the record, I'm a victim of that threat. Because I was bundled.
Your Honor, I wish to object to this kind of. Your Honor, no. We are here.
I have a police reference to this. I have a police
And it is
to this.
because you are suspect in another case. So, Your Honor, let's court business. We object to the way my landed brother is conducting court business. We are here for a response to this application.
Respond to this case.
Yes, Your Worship, I was giving you a threat that I faced and the condemnation is that because I'm representing these people. I have a police bond to that level.
We vehemently object. We vehemently object. This application was to regulate the media covering these proceedings, not to ban them. Now, for my learned brother, it is ludicrous that he is going into things that are unrelated.
And that's why I'm begging counsel, stick to this.
Yes, most
stick
obliged.
to the prayers made by state.
Most obliged, Your Worship.
That make it hard.
Yes, because I'm still on the security of the person involved in this matter.
Unless you're saying you interpret the state that we are all under threat.
No. Your Worship, I'm saying that the state has capacity to provide.
Because it seems like you're saying that
No,
something.
I'm saying the state has the capacity to provide security to its witnesses and us, if at all the state. But let me proceed, Your Honor. As I earlier said, the witnesses are not yet known to court, and no witness has ever been presented. So, it is not correct for the state to say that there are no witnesses affiliated by us, and that record should be disregarded. Your Honor, I'm going to go to a decision of Justice Eddy in Uganda Court Reporters Association Limited versus the Attorney General. It's Civil Division Miscellaneous Code number 87 of 2014. And it was for judicial review.
Copy, please.
Your Worship, the brief background is that the Chief Magistrate at Uganda Road had blocked trial in a camera of some accused persons who were allegedly under a high-profile case involving police officers. And upon that decision, the association made a review application for Justice Mugambe. And in Justice Mugambe's ruling, she had this to state while overturning the decision of that magistrate. I've given the court a copy. And Your Honor, in that ruling, the land judge said that the state cannot simply invoke national security to block media.
What? Page number? Page 3.
That the state cannot simply invoke national security to block media. It must provide concrete evidence. It's page 11. It must provide concrete evidence about the same with security. That it is not enough to raise state security without more. Some continuous. It is for the court to determine whether a matter falls. It is for the court to determine whether a matter falls within the exception of Article 41. That is Article 41, access information or not. And to do this, the state must produce evidence upon which the court can act. Worship, this was also referred to in the case of Major General David Nyefuza versus the Attorney General, Constitutional Petition number 1 of 1996, which was referred to by my colleague in his application. So, Your Worship, where the state has not provided any factual evidence regarding the security of the persons involved in the matter, the court should just ignore that as a mere allegation. And disregard this application. Worship, in the same decision, Justice Mugambe also emphasized the matter or the importance of an open justice principle. Worship, in that decision, Justice Mugambe emphasized that the open court principle is the fundamental pillar of a fair trial. The open court principle is a fundamental pillar of a fair trial, and that any limitation must be justifiable. Any limitation must be justifiable in a free, fair, and democratic society, as under Article 28, 41, and 43 of the Constitution. Your Worship, court also looked at the compelling rights, and that is page 11 as well. paragraph 34. In this case, the different judges discussed through the importance of open justice through hearing in open court and the role of media access to legal proceedings, as well as the process to be adopted in such applications for when it is to be banned. And they referred to Justice Masenke DCJ at page 39 in Major General David Kiza versus the Attorney General, where the land DCJ by then, as then was explained, that although the right to open justice is not absolute, in each case where derogation is sought, the court will have to weigh the competing rights. The court will have to weigh the competing rights or interests carefully with a view to ensuring that the limitation placed on open justice is properly tailored and proportionate to the end it seeks to attain. And Worship, the same decision emphasizes that open justice system is an integral part of the constitutional vision of an open and democratic society. I worship, as I'm about to conclude on this, on page 12 of the Uganda Journalists, Uganda Court Reporters Association, page 12, and that is specifically paragraph 37. The land judge referred to the case of Bifo, son of Mandile, versus it is quoted in the decision of the Supreme Court, where it was held that justice should be done openly, save in special circumstances for which statutory provision to the contrary is made, and save in certain other very unusual circumstances it is better that a man should not be brought to justice at all than that justice should be done to him without the public being given the opportunity of seeing it done. Your Worship, it's utmost important that this honorable court be pleased to continue allowing the media and journalists to conduct live covering of the proceedings which would leave out any bias of bad reporting or misinformation regarding this matter. Because the media are seen as the eyes and the ears of the general public, and any interested party who are unable to attend court. Therefore, Your Worship, the media only acts as a surrogate. Media acts as a surrogate for the public in ensuring accountability within the justice system. Then I will invite my colleague to proceed the application. As a reply.
Your Honor, my name is Eddy. Your Honor, in addition to the submissions made by my colleague, I wish to add on that prosecution's application to ban the media from live coverage and reporting of the matter before you has been brought with unfairness or in bad faith. Your Honor, I'll refer you to Article 41 of the Constitution. Right of access to information. You know, if court permits, I will reproduce the law. You know, every citizen has a right to access information in the possession of the state or any other organ or agents of the state, except where the release of the information is likely to prejudice the security or sovereignty of the state or interference with the right to the policy or any other person. Your Honor, as my colleague submitted, the accused persons comply with one of the popular political organizations called the Mutwe, for which they have supporters and followers. when court bars media from covering or having live coverage in this matter, this will be a deliberate denial by the state for the followers of the accused persons to access information related to the matter before you. You know, the law goes ahead and says, except where the release of information is likely to prejudice the security or sovereignty of the state or interference with the right to the privacy of any other person. Your Honor, prosecution has not in any way adduced evidence to justify that media will prejudice the security or that they will interfere in anybody, whether they are witnesses and that it should be barred from covering this matter. No evidence has been adduced by prosecution. Well, again, Your Honor, I invite court to look at Article 28 of the Constitution. The right to fair hearing. Your Honor, a right to fair hearing is not only on the side of the accused persons, but also on the side of the state. And Your Honor, one of the pillars of right to fair hearing is having the media covering and reporting whatever is happening in court. You know, the covering and reporting by media is not only advantageous on the side of the accused persons, but is also on the side of the prosecution. So that the matter is adjudicated fair on both sides. I submit, Your Honor, that prosecution should focus on having this matter heard expeditiously and concluded, other than adjudicating issues that are speculations and conjecture. That the side of prosecution are threatening that the proceedings covered by the media will be prejudiced. Nevertheless, Your Honor, lastly, Article 126 goes to paragraph E of the Constitution. Substantive justice shall be administered without undue regard to technicalities. Your Honor, we pray that the matter is administered without the issue of technicalities adduced by prosecution, that media will prejudice the proceedings. I humbly pray that the application by prosecution be ignored and subsequently dismissed. So,
Your Worship, as brief as I can. One, if I on all of fours, Seven Kuma follow. As I was saying, Your Worship, if I on all of fours had proper my land brother for the prosecution, inform the court the application is to regulate media. Your Worship, it is on judicial notice that media in Uganda is already regulated. We have several acts of parliament that regulate media and regulations that do operationalize the said principal acts of parliament. To which, among others, we have Press and Journalists Act, together with regulations made there under. We have the supreme law of this land, which is the Constitution. Your Worship, also, I call upon you not to fall in a trap of the prosecution, since this court does not have the subsidiary role to make laws. The subsidiary role is majorly for local government and ministers. Your Worship, by allowing the application before you, before you go there, Your Worship, I wanted also to bring the attention that actually the government has put up statutory bodies to regulate media. The most eminent one being UCC, and I believe it has done a commendable job. I always see a prosecution dragging people, most of TikTokers, whom they feel they have gone against the state standards. UCC, that is Uganda Communication Commission. Your Worship, my land brother for the prosecution should be barred from approbating and reprobating. Why am I saying so, Your Worship? The innocent persons before you, as the Constitution dictates as of now, they have severally applied for bail, and Your Worship, you have denied bail on ground that actually the reasoning limited against public interest. And it is the same state now who is trying to bar the public from accessing information. Yet in all bail applications, that was his major ground in objection of that bail application. I pray that the court bars him from approbating and reprobating. You should not eat your cake at the same time you want to remain with your cake. You choose one. Your Worship, the prosecution under Article 120 of the Constitution of this land is mandated and well equipped with security, finance, among other equipments to drag whoever they feel has violated the already set laws regulating the media. And they have been doing this for the worship in public domain. Therefore, they should not act on fears and allegations which are presumptuous in nature. By denying the innocent before you and their relatives and the public to access what is actually taking place. Your worship, having media in a court not only helps people within a court's premises, but it sends a message to the intending lawbreakers that so and so has been convicted of ABCD. Much as ignorance of the law is not defense, your worship, media does a paramount job in educating the public what is wrong and what is bad. Most of this case before you, which is an awful dream. My grandmother in the village wants to know the Waisswa Mufumbiro fact state, but I'm not going to transport her to come to court. Witness. Your worship, granting the application before you, it will be a blatant attack on Article 40, Clause 2 of the Constitution, which is every person in Uganda has the right to practice his or her profession. Every person in Uganda has the right to practice his or her profession and to carry on any lawful occupation, trade, or business. Your worship, these people here are here practicing their profession. Therefore, allowing my land brother application before you shall be an attack to how they earn a living, your worship. And they already have an association where they belong, and it will also be an attack to Article 29 of the Constitution. Your worship, Article 29, 1A dictates that every person shall have the right to freedom of speech, expression, which shall include freedom of the press and other media. Your worship, this will not only curtail them, but even the person who is not here with us, your worship, to follow what is taking place in court. Your worship, Article 120, Clause 5. Allow me to read it verbatim. In exercising his or her powers, that is the prosecution, under this article, the Director of Public Prosecution shall have regard to the public interest, comma, the interest of the administration of justice, and the need to prevent abuse of legal process. Your Worship, I will let this to us lawyers. The way you prepare when you are going to court, you know you are going to be on media. You try your level best not to be saying abuse of court process. Does not only actually help the accused person, as the lawyers, the media, but even the nature of services, which prevents the prosecution from being cited in abuse of court process, and that's the defense lawyers. That is Article 120, Clause 5, Your Worship. Your Worship, why we are insisting that media actually they have to do live coverage. This will prevent misreporting, and it also will discredit such media house or personality, because the person would have seen or watched the live proceedings. It will be rare and extremely not possible that it will give my you are dragged to court. You have no defamation among others. That is why I'm buttressing the fire that you are